Okay, let's unpack this. Welcome to the deep dive. We take complex stuff, boil it down, and give you the really important, fascinating insights. Think of it as, your shortcut to being properly informed. Today, we are diving deep, really deep, into international law. Specifically, how nations manage to agree, or maybe more often, how they disagree on the big global issues. Our mission for this deep dive, it's to decode a really landmark 1951 advisory opinion. This came from the International Court of Justice, the ICJ. Now, an advisory opinion, it's not like a final judgment in a fight between two countries. It's more like the court giving its expert legal take on a tricky question. And this one, it's about reservations to the Convention on the Prevention and Punishment of the Crime of Genocide. Huge title, I know. But it basically changed the game for how countries sign up to important treaties when they aren't, let's say, 100% on board with every single word. We've got excerpts from the original opinion you sent us, and we're going to pull out the key bits, help you understand not just what the court said, but why it's actually still relevant today for how countries work together. Or don't. So picture the scene. It's 1950. The UN is pretty new. They've just managed to create the Genocide Convention. I mean, a vital agreement, right? Outlawing one of the worst crimes imaginable. But then, bam, a problem. Some countries wanted in, but they had, well, conditions. When they went to sign up to ratify or accede, they added these things called reservations, which were basically formal statements saying, okay, we agreed to this treaty except for this specific bit, or we'll apply this part, but in our own way. And the trouble was, other countries immediately objected. They said, hang on, you can't just pick and choose. These reservations weaken the whole point. So the General Assembly had this massive headache. Could a country be considered a party, a member of the convention, if other members rejected its reservations? It was this big legal gray zone. And it threatened to, pull apart this crucial agreement right from the start.
And what's really fascinating here, it wasn't just about the Genocide Convention, though that was the trigger. The whole question of reservations to treaties was already a hot topic in international law circles. The International Law Commission, the UN's body for developing legal norms, was already studying it, and different ideas were floating around because it hits on this fundamental tension, doesn't it? How do you get broad agreement, which you need for global rules, while also respecting that each country is sovereign and only consents to what it explicitly agrees to? How do you balance that national consent with keeping the treaty effective and whole? That was the core puzzle.
Right. And that puzzle led the UN General Assembly straight to the ICJ with three specific questions. They were framed as abstract questions, but really targeted this Genocide Convention problem. Question I basically gets right to the heart of it. Can a state join the club, keep its reservations, even if some other members object? The exact wording was, can the reserving state be regarded as being a party to the convention while still maintaining its reservation, if the reservation is objected to by one or more of the parties to the convention, but not by others? And this is where it gets really interesting, because, the old way of thinking about treaties.
The traditional approach.
Yeah, often borrowed from contract law, was super strict. It basically said a reservation is only okay if everyone agrees to it.
Exactly. The so-called rule of integrity. The treaty had to be identical for all parties. Like a contract, you can't just unilaterally change the terms after everyone's signed.
No cherry picking allowed.
Precisely. But the court, looking at this, recognized that rule but felt, well, maybe this situation needed a more flexible approach. They pointed to a few things. First, the UN itself. Its whole point is to be universal, global.
Aiming for maximum participation.
Right. And the Genocide Convention explicitly called for very wide participation. So the goal was clearly to get as many states involved as possible. Plus, they noted that practice in multilateral treaties was already shifting a bit. Sometimes, if a state didn't object to a reservation, it was seen as tacit agreement. Silence meant consent, sort of. And crucially, the Genocide Convention itself, although it was approved unanimously in the end.
Which sounds like everyone agreed on everything.
Well, yes,
Yeah.
but the drafting process involved a lot of majority votes on specific articles, not unanimous votes all the way through. This background suggested that reservations were almost a necessary tool for some states to be able to join at all. We know from the records, the preparatory work, that some delegates literally said they could only sign or ratify if they could make certain reservations.
So reservations weren't just an afterthought. They were part of the negotiation reality.
Exactly. And the court also noted that just because the convention didn't have an article about reservations, that didn't automatically mean they were forbidden. It might have been left out deliberately to avoid encouraging too many of them.
Okay, so lots of factors pointing towards flexibility. But how did the court actually decide? What was the deciding principle?
The deciding principle, the crucial criterion, came from the nature of the Genocide Convention itself. They looked at its origins, its purpose. The UN had condemned genocide as a crime under international law, a denial of a group's very right to exist. It had this purely humanitarian and civilizing
And
purpose.
wasn't about trade deals or borders.
No, exactly. In a convention like this, the court said states don't really have individual interests in the normal sense. They share a common interest. What's that common interest? Achieving the high purposes of the convention, preventing and punishing genocide. Therefore, the test for whether a reservation is acceptable or not couldn't be unanimous consent. It had to be something else. And that something else was compatibility with the object and purpose of the convention.
Compatibility with the object and purpose.
Yeah,
Okay.
that became the benchmark. Is this reservation fundamentally undermining what the treaty is trying to achieve? Or is it a more minor point that still allows the main goals to be met? And importantly, this test limits both sides. It limits the freedom to make reservations. You can't make one that guts the treaty, but it also limits the freedom to object. You should only object if you genuinely think it is incompatible with the core purpose.
So each state has to kind of make its own judgment call based on that principle.
Yes, an individual appraisal, guided by that common standard, object and purpose.
Right, that makes sense. It's a profound shift from just counting votes. But okay, if that's the principle, what are the practical consequences? If some states accept a reservation and others object, what actually happens? That was question 2, wasn't it? If the answer to question I is in the affirmative, what is the effect of the reservation as between the reserving state and A, the parties which object to the reservation, B, those which accept it?
Precisely. And the court's answer here, it was actually quite divided, a 7-5 vote on both parts. But the majority view laid out this system. For Part A, the objectors. If a state objects because it considers the reservation incompatible with the object and purpose,
Based on that test we just talked about.
yes, then that objecting state can consider the reserving state as not being a party to the convention, but only in relation to itself. The treaty relationship between those two specific states doesn't exist.
Okay, so it's bilateral. It doesn't kick the reserving state out entirely.
Not necessarily, because then you have Part B, the acceptors. If a state accepts the reservation, maybe thinks it's compatible, or just decides not to object, then it considers the reserving state is a party to the convention, and the treaty is enforced between those two, including the modification made by the reservation.
Wow. So you can have this really messy situation where State A thinks State B is a party to the treaty, but State C thinks State B isn't a party.
Exactly that. State B might have different treaty relationships with different states under the same convention.
That sounds complicated.
The court admitted it. They acknowledged the disadvantages of this possible divergence of views. But they argued it was sort of mitigated because all states should be guided by that same objective test compatibility with the object and purpose.
A bit optimistic, maybe? But I guess it prioritizes getting more states under the umbrella, even if the umbrella looks a bit patchy.
That seems to be the trade-off, yes. Broader participation versus absolute uniformity.
Okay, so that covers states that are already full parties. But what about those on the sidelines? The UN's third question dealt with objections from states that hadn't quite committed yet. Question 3 asked, what's the legal effect if an objection comes from A, a state that has signed but not yet ratified the treaty, or B, a state that's just entitled to sign or accede but hasn't done anything yet?
Right. These are important nuances. For scenario A, the signatory that haven't ratified, the court ruled, again 7-5, that its objection only gets legal teeth, only has the effect described for question I after it ratifies.
So before ratification, the objection is just like a warning.
Pretty much. The court called it a notice to the reserving state. It signals the signatory's future position, but it doesn't block the reserving state from becoming a party in the meantime with respect to other states. It's like saying, just so you know, when I fully join, I'm going to object to this.
Okay, and what about scenario B? The state that's just eligible hasn't even signed.
For them, the court's answer was simpler. Their objection has without legal effect, zero impact.
Makes sense. They haven't made any commitment yet.
Exactly. They don't have any rights under the convention at that point, so they certainly don't have the right to influence who else can be a party or on what terms. The court was clear. Just being a UN member or getting an invitation to sign doesn't give you the power to exclude another state. You need to actually take steps to join yourself.
Got it. So wrapping this up, it feels like this 1951 opinion was a really pivotal moment. The ICJ took this knotty problem around the Genocide Convention and basically established a new framework for thinking about reservations, didn't it?
Absolutely. It moved international law away from that rigid contract-like all-or-nothing integrity rule, at least for certain types of multilateral treaties.
And put the focus squarely on the treaty's fundamental goals, the object and purpose.
That became the guiding principle. Is the reservation compatible with why this treaty exists in the first place?
It allowed for more flexibility, potentially wider participation in crucial humanitarian agreements, even if it meant accepting a bit more, well, legal complexity between the parties.
It fundamentally shaped how we handle reservations today. This object and purpose test is still the standard benchmark used in treaty law, stemming directly from this opinion.
So we've unpacked how the court tackled this specific dilemma for the Genocide Convention, establishing that crucial object and purpose test. We saw how it created this flexible, if sometimes complex, system where a state's status as a party could differ depending on who you ask, the objectors or the acceptors. And we clarified who actually gets to say, basically, you need to be a committed party or at least have signed for your objection to potentially count later on. This whole deep dive really shows the ICJ navigating a major shift in international law, moving towards a more purpose-driven approach for these big universal conventions.
It does, and maybe the final thought to leave you with is this. Consider how that trade-off plays out today. This ruling essentially prioritizes broad participation in vital treaties, like those on human rights or environmental protection, over strict uniformity. It accepts that states might have slightly different relationships under the same treaty. So the question is, does this flexibility ultimately strengthen international law by bringing more actors into the fold, even with variations? Or does the lack of complete uniformity potentially weaken the overall impact and enforceability of these crucial global rules in the long run? It's still a live debate.